So now we're going to move swiftly on to NFTs and regulation, thinking about IP, property rights, and policies. So now I'd like to introduce Kyle Lawrence, Charles Slamowitz, and Agustin Barbara. Welcome. Okay, guys, our speakers are ready for the next talk. If you could please settle down, get comfortable again after the last one. I know it was a good one, but our speakers are ready. Thank you.
Hi.
All right.
Hi.
Mic check, 1 2 1 2.
Good morning. Is this? Yeah, okay.
Yeah, you're good.
My name is Agustin Barber. Thanks for being here. Quite early, didn't expect this turnout for NFTs and regulation in the legal field on a Thursday morning, but it's great to be here. I am the managing partner of the Crypto Lawyers. We are based out of Miami, Florida. All right, Miami. We specialize in all things crypto. My background is in patents, specifically blockchain technology. So we represent everything from NFTs, project launches, trademarks, copyrights, trade secrets, and everything in between. So happy to be here.
Yeah, good morning, everybody, and thank you all for being here. It's really early, but amazing. I am Charles Slamowitz. I'm founder of Slam Legal. We're a Web3 advisory services in the United States. We've counseled over 50 projects, and the real goal here is to help companies, whether international or nationally within the U.S., penetrate the U.S. market. So this deals with securities laws. This deals with kind of running the gamut between, NFTs for good, which we're going to talk about a little bit more. But at the same time, I've done Robinhood crypto. I've done Snoop Dogg NFTs. I've kind of done it all so far. We're all learning in the space, but we've all gotten together. I'm grateful to be on this good panel out here because we really want to give you some insight into what's going on with the regulation and, whether it exists or not and how to navigate. So excited.
All right. Good morning, everybody. Kyle Lawrence. I am the co-chair of the Emerging Technologies practice at Falcon Rappaport Berkman. We are a full-service firm that does pretty much anything you could possibly need. I grew up in traditional finance on Wall Street, doing the corporate mergers and acquisitions, all that good stuff that is very boring, and migrated over into blockchain a couple of years ago. And that's not what I look like. I look like this morning. It's a little rude awakening, but now I'm all good. So thank you, everybody, for coming. I know it's a fascinating and terrifying time to be in the space with everything that's going on. So I guess maybe we'll start over there and work over this way.
So we were talking this morning about everything that's going on when it comes to what is regulation, and so what once was the traditional PFP is no longer, right? Everyone's being more creative and sort of expanding boundaries, if you will, as to what these traditional NFT projects can do. So that comes with some serious implications, right? So it's no longer, right, your profile picture with your traditional roadmap. Once we reach it, then we'll do, a T-shirt. You get a T-shirt. We're talking real estate. We're talking dividends. We're talking tokenization components. And so there's a lot of gray area as to what are we going to do from a legal perspective, because there is no precedent, right? And so, you want to chime in on that?
Sure. Well, it's, like I said before, it's kind of very interesting and fascinating and terrifying. But just show of hands, who here has actually launched their own NFT project or token project? Did you seek the advice of counsel when you did that, and did they terrify you, about that? Somewhat. A year ago, as Agustin was saying, we were just inundated with we have a 10,000 NFT project, 10,000 PFP project. We don't know what we're going to do, but we just want to launch right now. And they figured, well, these things are not securities. There's no regulations. We can just do whatever we want. And sadly, that is not the case. At least in the United States, where we have reasonable partisan lawmakers who get things done in a manner that makes sense and is efficient. Obviously, that's not true. You have to be very cognizant of the fact that when you launch these projects, there are laws in place that govern them. They may not be necessarily completely analogous. You know, the securities laws in the United States are close to 100 years old, but that's what they're using to determine what's legal and what's not in terms of your NFT project or your token project. I don't want to monopolize because this is going to fly by, so why don't you chime in?
No problem. So, you know, I think that we could really distill it down to two issues within the United States and internationally as well. Number one would be, is your NFT project a security? And this is basically a question, you know, throughout the world. The Gensler administration within the SEC right now, you know, released that they own Ethereum within the US, that everything's a security. Yep. We don't have much guidance over there, but at the same time, I've navigated the space. We could talk a little bit more how to make sure, to the best of our abilities, that it's not a security, even within the US, through twofold processes. One through like the nonprofit route, the other through the DAO route. And secondly, it's more about whether or not you're committing wire fraud. The biggest case right now, you know, with OpenSea was if you have somebody, you know, knowing that something was going to be posted as an NFT, is it insider trading or not? And, you know, we don't know whether it's insider trading, but the way that the courts typically work is to say, there's nothing new under the sun. Let's pretend that decentralized assets don't really exist until we get it under control. Obviously, the UK is doing a much better job and, you know, notifying and saying this thing exists. IRS is trying to as well. But if you make a promise in your roadmap and your white paper and your light paper, whatever it is, you could be taken for wire fraud. And the second that you make a promise that doesn't exist across the state lines, that's where you could kind of get screwed, if you will. Pardon my French. But basically, you could have your assets frozen. And until the regulatory bodies figure it out, there's nothing you can really do. So not making a promise, I'd say, is a very important number two.
You know, the other thing, I'm just seeing property rights, like right there on the screen. And so what are the property rights? Right? So traditionally, the old school method was, old school, right, with a couple of months ago, was you don't grant any commercialization rights. But now we're seeing a shift in that. Bored Apes is a perfect example. Goblin Town now as well, that they go for the CC0, which is the Creative Commons license, which essentially, not Bored Ape, but I'm referring to Goblin Town. But so now you're giving this IP to the community and letting them develop and grow. And so even with that component, you still have to make sure that, okay, you can take your NFT, commercialize it, monetize it. Let's just say you want to do, I don't know, a water bottle company, right, with your NFT. However, the actual trademark in and of itself, so for example, in this case it would be Bored Ape, right, that you cannot license, otherwise it would be considered naked licensing, right? And so you have to protect your trademark, however, you can grant certain rights to the actual project itself. And that's a great way, you know, there's pros and cons to it, but a great way of reaching a different market and letting the community take your brand to another level.
And one benefit of giving these rights to the community members and giving them a sort of say in the direction of the project is it somewhat moves it out of the quote-unquote securities territory. It's not a fail-safe. It doesn't work 100% of the time, and the SEC is casting a very wide net. But just for the sake, I feel like we have to say it, what is a security? A security is an investment of money in a common enterprise with an expectation of profit derived from the efforts of others. So if I give Charles money to invest in a piece of actual property, real property that exists in the world, and I sit back and do nothing and just collect my dividends, that's a security. But if you give these certain rights to people, say, you know what, we have this treasury, we want to deploy the capital this way, it can potentially at least give you an argument that you are not a quote-unquote security.
I mean, that's right. So what Kyle's really saying too is that you have to also include some effort. A super important part of the subsequent, latter 2 points of the Howey test. And I think what we're really looking at here is, from a perspective, when you look at an NFT project, you have to think, of course, how are the rights divided up and who gets what. It's very nice that we've reached a place where we have a lot more control as artists, as companies, as holders about what to do with the IP generally. But yeah, I think that there's just a lot of changes going on. The primary issue right now is we're trying to figure out the paradox of NFTs and who has what money. Yuga Labs basically owns the catalog of Bored Apes, but at the same time, the Bored Apes holders own the IP. So there's a question right now as to who did it. I just had a lunch with the lawyer for Ryder Ripps, one of the cases prevailing right now, and we're talking about essentially forcing the issue and saying, well, you know, you kind of got to choose. Because right now, if you're a company that owns a catalog of IP, you could be valued at $3 billion or several hundreds of millions of dollars right now if you look at certain projects. But then how do you really own it if the owners own it? So this is something that just hasn't been sorted out.
But, you know, right now everyone's talking about securities and so forth because it's like the sexy thing to talk about, but do you think there's a lot can be done without going into that sort of gray area? I think there's tons to be done where you can play it safe and kind of avoid this sort of dilemma until we have some sort of guidance, because right now, you know, yeah, you could probably pull it off, but it's also low-hanging fruit for the SEC in the States anyway. So licensing is you know, is a great example, but do you see that sort of, would you agree?
Yeah, that's a great point, Agustin. And, you know, licensing has certainly become more prevalent in our practice, you know, a lot fewer of just the traditional, like we were saying before, of the PFP projects, and there is a lot more of a licensing component, more of a community-driven aspect to the projects. I'm more in the finance world than I am in the intellectual property, you know, world, but there's definitely been a big shift in the clients and the you know, requests for consults that we've been getting, which is more of a, yes, who owns these rights? I mean, it's a great point you guys are raising. Is there a clearly delineated path to, you know, success from a regulatory standpoint? You know, not exactly, because as everyone is saying, you know, Gary Gensler, the SEC chief, is saying everything is a security, and then of course yesterday Hester Pierce just says, you know what, the way we're doing this is completely backwards. We can't be doing it this way. So even within the SEC, there's discontent.
The biggest point, too, is that there are cases right now where the SEC was compelled to produce documents, and if you had been following the news, you could see the internal emails that were released through Discovery essentially confirm what we already knew. The SEC doesn't know what the heck they're doing or what they're talking about. At the highest level of the SEC right now, you know, SEC won't let me be.
Is anyone from the SEC here before we actually begin? Okay.
I had just spoken in Camp Decrypt with some ex-SEC people. I had just met with the SEC recently on 2 prior projects where they gave me no further action and no action letters, because the thing right now is that you just can't do anything that just looks terrible. Even the domain of the UkiDAO case, where you have the CFTC jumping in, basically saying that, you know, the CFTC was supposed to really regulate the United States, but the SEC kind of jumped in as well. And they said, you know, Kim Kardashian tweeted out something, and, you know, Instagram, and the SEC's like, wait a second, even though the FCC is supposed to take care of this, we think this is a security as well. Yeah. So it's a little muddled. But I just want to give you guys, you know, I guess, like money for your time, if you will. Like, you came in early, and I just want to spit some knowledge and kind of help you out a little bit. So the 2 trends that I've primarily been seeing is, one, if you take the nonprofit route for an NFT, you're able to, you know, let's talk for a second within the United States. There are blue sky law states where basically these states, like California, defer to the federal government. And what the federal government says that if you're doing a nonprofit, you're essentially able to issue a security without having a lot of the other regulations. You don't have a vesting period. Sure, there are disclosure requirements, but under Section 4AC, within these acts, if a 501c3, you're actually able to essentially issue something. This hasn't been tested yet, but some of the top firms that I've worked with and projects, we're taking this route as well. You know, the SEC, which we have spoken to, basically said, why are you telling us this? Which is very nice, because it's essentially precedent to say that if something doesn't change materially, we have some guidance here that it's not illegal. But secondly, as Kyle was pointing to, it's about a community. So we have a point here where NFT, the users are highly engaged. So why don't you give somebody something to do with their NFT? If they're contributing value to the project, that's our best chance also within the DAO structure ensconced there to not be a security.
Again, and I'm kind of the, not anti-SEC, but ways that we can avoid it for now until we have some sort of guidance, because you could be going and developing this plan, and then all of a sudden, it's shut off because it's no longer legal. The uncertainty is just, I mean, I've never seen anything like it anyway. So when you take, the, you know, NFTs and so forth, it's a product. You're still running a business. And so the way you, instead of making it your sole business, you can integrate it and further develop it. It can be used as a component for advertising. It could be part of your, I mean, just look at all the Web 2 companies, right? So we have Nike, Adidas, Tiffany & Co. just did some stuff with CryptoPunks. So there's so many ways that you can evolve this without necessarily having to go the traditional route as to what we're seeing. One great example, we represent Stanley Holdings, and they have an unreleased character created by Stanley called Slam Girl. It was just sort of released in Comic-Con in New York a couple of weeks ago. The point is that they're using the metaverse sort of NFT space as part of this development. They're not going all in on it. In other words, it's part of it. They're using it for marketing. However, you can still have your traditional sort of Web 2 traditional streams, which would be T-shirts, comic books, action figures. So you don't necessarily have to go the route that we usually see to be successful in this space. In fact, I would advise against it because it's so stale now. Use it, but use it as a supplement, not as your main sort of course, if you will.
Yeah.
No, please.
Going the metaverse route is also a very important thing that we should all consider as well. Even if you're just dipping your toes in the metaverse, it's not a dirty word. In fact, it really helps projects because you could create value within metaverses, intrinsic value by getting sponsorships and brands to join your metaverse, and it's much less likely to be a security because, again, we're contributing more value. So a lot of projects that I've counseled, I do LostCity.com, which is one of the largest metaverses, Studio 54, the Viper Room, et cetera, a couple stealth projects as well, which you'd be surprised, these institutions that are creating metaverses. But the idea here really is to essentially shield yourself as well from liability. We see metaverses are very highly engaged. We see people with NFTs could get access to those as well. And just one quick point as well, I think that what we need to really worry about too, besides the regulators, is big tech. And the truth is these walled gardens that are coming out right now, Apple announcing that you can't have token-gated access to certain ones of their apps. You could see Amazon right
30%.
now. Yeah, and 30%. And also they're just restricting entirely certain token-gating experiences as well. Big tech isn't going away. You see Mark Zuckerberg testify in front of Congress where they don't know what's going on. And then you see Cardano testifying. Congress is way behind. We're figuring out the laws ourselves. Who's getting paid a government salary to create something that's actually going to work? The primary issue here is even if the government could regulate big tech could pay a fine and move on. So you really have to be cognizant about the Googles, Amazons, Facebooks of the world, even Twitter now, which is creating really, really integrating as a gateway to NFTs as well.
I'm a big fan of Scott Galloway, who teaches at NYU, who's very prominent about big tech and the big four, as he calls them. And if we had 6 hours, I could kind of wax poetic and bore you all to tears about it, but we're not going to do that. But as Charles was saying, and as Agustin was saying, you want to protect yourselves. When we talk about what is the security and what is liability, I don't want people to think that if they're issuing an NFT or a token that being a security is the worst thing that they can do. It's not this, Michael Myers boogeyman that's going to come and kneecap you. It's simply just a matter of compliance. It's okay to be a security. It just means that I get paid, which is great. And also it's great for you because now you won't have personal liability if somebody comes after you. So I think that the mistake people were making, in yesteryear was, I was saying before, these things aren't regulated. We can do whatever we want. And then you have the SEC just kind of fumbling its own hands and saying, well, this is a security. And then Hester Pierce is saying it's not, and all that kind of stuff. But it's okay to say, you know what we're doing, we want to give value. We want to be able to sell this token or sell this project and people to make money on it. It's okay to be a security. You don't have to be a reporting company. You're not filing 10 Qs and Ks just because you're a security. But it's incumbent upon you as project founders and project participants to understand what your risks potentially are, what the liabilities potentially are, and then weigh it against what the potential benefits are. And any one of us can walk you through what that means for you. So if you see us floating around the conference, please don't hesitate to ask us that.
Yeah. The takeaway here is, why are we here, right? We have the microphone, but we might as well just be, sitting amongst you as well because we're still figuring it out. I have things to learn. you know, we were just learning things off each other, just talking in the other room. But why are you here? And the fact that you are here means you're already one step ahead. It means you're wanting to learn, you're wanting to integrate in the space, and that already puts you at a significant advantage. We don't have to have it all figured out, but we have to have a good foundation and be proactive about it. And I think everyone in this room, well, represents that. We're here because we want to know what we can do in such a way to contribute to this space. And that, I mean, it's fantastic. It's a great space to be in. And don't be, you know, it's like anything. You find a balance, but this shouldn't dissuade you from pursuing these projects, because there's so much innovation, so many great things that can be done. And because we're here so early, there's going to be growing pains, there's going to be uncertainty, but that should be something to overcome. It shouldn't be a barrier. It should motivate you as well.
Yeah, and a lack of regulation is really where you can make the most money and the most change in a certain period of time. So it's certainly important to navigate the space and to, you know, piggyback off what Agustin said. Look, at the end of the day, lawyers intrinsically don't really guarantee you anything. We're going to do the best we can, but every contract you look at, we're not going to guarantee you're not going to get sued.
Don't tell them that.
But you know, at the same time, I think putting yourself in this room and putting yourself in this place, we're going to be light years, eons ahead, 2 to 3 years ahead easily. Every client I work with, I have 4 or 5 legal theories that I implement into projects to ensure that you're ahead of the game, to ensure that you have a good mission, to say, you know, if you look at the cases that are happening right now, a lot of them are doing something bad. And you could look at Celsius or Tornado Cash or the true evil players. And these regulatory bodies are saying, okay, we don't really know what the law is, but we know that this isn't good. So they're really trying to work on that, and having the right guidance and attorneys like us to work with you, I think will really help you navigate. And, you know, worst case slap on the wrist, but thus far, I don't know if any of us had anything bad happen to any of our projects. No guarantees, but, you know, nothing so far.
Thankfully, guided by the expert stewardship of my firm, none of my clients have gone to jail. Actually, in 16 years, I've never had a single client be persecuted by the SEC, not one. And this is what I do for a living. Don't tell them that we don't guarantee. You're not supposed to say that. But I kind of lost my train of thought with that. That's all right.
You know, but nothing is risk-free. What we're doing is trying to mitigate it. There's no guarantees. Right, even if we're doing everything down that we think is going to satisfy all the criteria from a legal component, there's still going to be some angle, there's still going to be liability, there's always going to be someone subjecting you to suit. However, what we're doing is putting essentially a barrier, right? Creating a moat, putting an alarm system, some guard dogs, everything in place. So is it impenetrable? No, it's not impenetrable. However, it's going to be a lot harder than just having a house, right, with one lock. And when you look at it that way, you're putting yourself in a position where you will not be low-hanging fruit, as I mentioned earlier. However, you know, this is all new, and there's no guarantees. It's constantly changing, and the best thing we can do is interpret it based on what we know, what has happened, and apply it to where we're going, at least in that direction anyway.
Yeah, and the primary thing here is, you know, we want to ensure that innovation isn't stifled. So I've sold 2 startup companies before I became an attorney, and the reason why I had done that and practiced law is because I'd realized a lot of lawyers told me no. Also, a lot of lawyers were always difficult to work with. I sat in a board meeting once for 2 hours waiting for a simple NDA to disclose a wearable technology that I created. And I realized that you need to work with the lawyers, you know, every step of the way to create those decisions. And if done correctly, you could actually make a lot more money by working with lawyers. I've helped companies raise money, helped a company raise $10 million after they were hacked for $5 million because we were able to put implements and safeguards in place through audits. It's just a matter of like working and navigating the space and really thinking about, you know, Web3 is really about collaborating, not competing. So it's very nice that we're working with accountants, we're working with different artists, and I think this is a very new space, the fact that we have the blockchain and that we have the transparency involved. That, you know, if lawyers were a lot more collaborative like us, it would be nice to include them into the fold to make your project more likely to be a success.
Yeah, it's a great point. I guess I get the outro. You know, we view ourselves as part of the process, not a necessary evil like a lot of people unfortunately view lawyers. And I get it. I don't want to pay lawyers either, but it is important to have people who understand not just the technology and the space, but where this industry is headed to, because it's definitely moving in the right direction. It's important to work with people who know that, not just, oh, let me hire the lawyer who helped me sell my house. You don't want that. You want the three of us. So.
Thank you. Thank you for being
Thanks,
here.
everybody.
Thank you so much.